Hey y'all, what's up? It's your girl Shark. Y'all know what time it is. Hit that like button, turn your notification on, and subscribe to the channel because I promise you, you won't be disappointed. Listen, y'all make it do what it do, what it do, what it do. And remember to speak when you walk on in the chat because ain't nobody sleep with you last night. If you haven't had a chance to follow me on any platform, go ahead and follow me at Shar's Reality number 6. If you haven't had a chance to follow my backup page, please do at Shar's Reality Family. Hello to all my newcomers, flip-floppers, and day ones. What's up and la-di-da-di to everybody. Unfortunately, this is not a chat for children. So if you are a child, I'm sorry, you have to exit stage left. All right, now that we got all the accolades out the way, let's go. So here's what we're going to talk about today. We're going to talk about two things, and Karen is our main focus, okay? But I want you guys to understand that just like Karen, Kays has all, or have us all in the suspense of like, dang, what is going on behind bars with Karen? Why did they put the hammer down on her so hard? What is going on with Karen Huger? Okay, what is her husband thinking? What are the children thinking? Like, what is going on? Now, I saw a picture where Karen had a mug shot where she had her wig still on. Now, I said, what county, what jail? Because, baby, they strip everybody of their wig. So, by her not being stripped of her wig, I'm going to say that maybe she had a little compassion over there in the jail that she is residing at for the next 365 days. Well, wait a minute. She did 5 days already. So 360 days, maybe somebody got a little bit compassion for her, which can be good and it could be bad, right? Because y'all know inmates don't like for folks to be showing no type of favoritism to somebody. So listen, she walking around there in her wig and them other girls got to walk around there in their cornrows. This could bring some beef to Karen Way. Now, I'm just saying, this is what I believe and my shana. All right. So with that being said, we all wish Karen well, but we all have questions. So I was scrolling through the YouTube streets and I was able to go across Carlos King, and Carlos got the drop on Karen. Okay. And we're definitely going to listen to it, right? He got the drop on Karen. He inserted or invited an attorney by the name of Ebony over to his live, and she gave us the tea. And we're going to listen to that and see what she had to say, because it's always nice to get another side of it from the legal standpoint. Like, dang, what was it that the judge was not with, right? Why was it that they came down on her like this, right? Because we see a lot of people get off. Now, I'm not saying that anybody should be let off, but I am saying like that it seems like they had a point to prove for Karen. All right. So let us listen to that. Before I play that, you guys remember, hit that like button. All right. Let's jump into it.
All right. So let me start by answering that direct question and I'll retro back. So the answer is, Carlos, somebody can get up to 4 DUIs, as we see is the case with Karen, and never serve a day in jail up until this point because of two words: judge's discretion. That's the why. There is, for most states, I should say, and this is very much raindrops, this is a state-by-state scenario, legal scenario. Each state is works differently, rather. Karen, we know, is in the state of Maryland, is adjudicating this for Karen Huger. So in the state of Maryland, whether or not a particular conviction gets active jail time, we call that an active sentence, or probation, or house arrest, or whatever the determination of sentencing looks like, Carlos, it is exclusively up to the judge's discretion, meaning what the judge feels is appropriate. Now, let's be clear. Prosecutors can make a recommendation. So a district attorney can say, I'm sure historically in Karen's previous 3 DUI convictions, made a recommendation to the court. Well, the district attorney's office recommends 6 months. The district attorney's office recommends 1 year, 30 days, weekend sentence, whatever. The judge is not bound by it, Carlos. Judge ain't got to do a damn thing but what the judge wants to do. So the fact that we have seen Karen avoid an active jail sentence up until this point, I'm going to tell you in my legal experience, and I used to specify DUIs heavy in my practice when I practiced criminal law in North Carolina. Probably 30% of my caseload as a public defender were DUIs, so I know this one very well. I've never seen somebody get to a 3rd DUI and not serve an active jail time. Haven't seen it. And I was sworn into practice in 2007, so y'all do the math. 18-ish years as a practicing attorney. So I will say that's exceptional for those of you that are scratching your head once you found out. See, many, and this is how it should be. I want to say this part too, Carlos. That means people are doing their job. That the public did not know what Karen Huger's prior conviction record looked like. That's a good thing. That is called the discretion of the court. Okay, but now that it's been adjudicated, She's been found guilty at trial at the end of 2024. Sentencing was on deck. Now we're finding out, okay, because as soon as I heard the sentence, I forgot where I was, but I was texting with my producer, shout out to Ashley Hobbs over at Holden Court, and I said, damn, they gave her 2 years, 1 suspended, so she's going to do a year in jail. I said, she must have priors. She must, because it would be unthinkable, unfathomable for a first-time DUI offender to get an active jail sentence, mostly at all, but certainly no more than 15, 20, 30 days. Somebody's saying in California, you do a mandatory 8 hours for your first offense. Very interesting. Okay, cool. So that's why I say, y'all, state by state. So anyway, yeah. But when I saw that Karen had an active year sentence with another year, as we say in the business, hanging over her head, that's how we refer to that suspended year. Because that's a mechanism that the...
Now, let me just pause right here. That's a really important fact that I think. Let's not, act like this girl couldn't hurt somebody. And I think the judge just was tired of her, okay? You came in with your 5-page letter to the judge. You cried tears. And like I said, Karen should have never, ever taken this case to trial. That's called a person that believe that they are right. They started to believe their story even though they know what the hell they did. And what happens is people started telling Karen, in my opinion, that she can get off. People started telling her, you got this, and then she was like, I'm going to take it to trial because I am that girl. No, you're not that girl. And the judge simply popped your hand and let you know how you really was not that girl. So I thought that was important. This is her 4th DUI, guys. Whatever she got after this, she deserved it. Right here in Jersey, baby, after that 3rd one, you're going to go do 6 months in jail, okay? Ain't even after that 3rd one. That 3rd one in a 10-year time frame, you are doing that 6 months in jail. And you're going to get that 10-year suspension on them license, okay? So ain't nobody got time to play with her. Let's continue to listen.
Judge puts in place to basically keep you on a short leash. To basically say, Miss Huger, you can you cuss on this? Yeah, go ahead. Okay. Miss Huger, you've been fucking around. You've been playing in our goddamn face, okay? As the judiciary, as it relates to the offense of driving under the influence. And so what we're going to do this time, we're going to do it differently. You're going to get an active sentence. The maximum you could have received was 2 years. I'm actually going to give you the max. Raindrops, do be clear. This judge gave her the maximum sentence, 2 active years of jail. He chose to suspend one as to say to her, if you breathe wrong, when you get out on day 366, if you breathe wrong, you're going back, don't pass, don't collect $200, and you will serve every day of that 2nd year. That's how that works.
Now, what they're talking about here is her basically getting a suspended portion of that for 1 year. They're talking about if she do anything wrong, put her shoe on the wrong foot, the judge can make her go back to jail to serve that 1 year of that suspended sentence, okay? So it's not like it's an erase, and it's indefinitely erased. You still have that hanging over your head until that 1 year is up, okay? So let's continue to listen. So here you're going to hear them have like a conversation about what she was offered or could have been offered. Right now it's rumors or speculations because no one can confirm it. So they're going to be talking about where they get that source from and where it could have happened and it could have not have happened. Okay, so let's go.
I really did do investigation here because I didn't want to come with speculation. So the only credible source, let me back that up. The only source, I'll let the people decide if it's credible, that I could find that gave that report, Carlos. And you're right; those were the reported offered plea deals. One of 60 days active jail time, the other of 6 months house arrest. Mm-hmm. It was a publication called TV Deets, DEETS, TV Deets. Mm-hmm. That is the only publication I can find on record reporting that prosecutors allegedly offered that pre-trial. Those are pre-trial. I'm not very familiar with TV Deets, so I can't speak to their credibility. I will tell you this. It is not uncommon, or indeed it is customary, for prosecutors to offer, especially what we call, which Ms. Huger is, a habitual offender. Once you get to 2 and 3 and now 4 DUIs, there's a name for that in the court. We call you are a habitual offender. So now when you're a habitual offender, you are often given an opportunity to adjudicate pre-trial. Okay, let's kind of wrap this up. We kind of been down this road before. We know what it looks like. We're going to offer something that's going to be reasonable by prosecution standards. Defense team will take it up with their client and see what they want to decide. Because I personally can't say TV Deets is credible enough for my journalistic standards. No shade. I can't say for sure that she was offered anything, but I can tell you if she was. if she was, Carlos, offered either of those, 6 months house arrest or even 60 days active jail sentence, it was a gift from the prosecution. She and her legal team should have taken it with a smile on their faces and went about their business.
Now, this here is the final rumor that Carlos is speaking of, and he's talking about whether or not Karen had someone else in the car at the time of the accident, and is it something that they can find on a public record. And the lawyer is going to explain that. The lawyer by the name of Ebony, I hate to say the lawyer, but she's going to explain what it means or not, or does it mean anything at all. Right, let's go.
Okay, so a few things. The file itself should not just be generally open, because that would kind of contaminate the sanctity, if you will, of what we do inside of a courtroom. So that's not going to be something that you guys could just access online, for instance. Okay, it's not like how we can look up Puff's federal indictment and complaint. That's a public record. It's only because a judge has unsealed the indictment. So that's why we have access to that. As the public, Carlos, we don't generally just get carte blanche access to all courtroom proceedings. It's certainly not at the district level for our consumption. So that's not available for public consumption. Now, whether or not there was another individual at the scene of the crime, because it was absolutely a crime, we now know, who's to say? Who's to say? Pure speculation. Whether or not it makes a difference, also who's to say? The only way I can see it making a difference, Carlos, is if indeed Karen wanted to make a defense claim that she wasn't indeed behind the wheel driving. It was this third party, this unknown, identified third party that was actually the driver, and then he or she fled the scene, leaving Karen to kind of hold the wheel, if you will. If she wanted to go down that road of a defense argument, she can have at it, but we don't have any evidence of that. That's the only way I could see that mattering, if you will, from a legal standpoint.
And now Karen was so toasty, she didn't know if she was driving with the birds, the stars, the moon, honey. She wouldn't have known if a person was in that car with her or not. Okay, she was done up. So I'm glad she didn't try to use that alibi, and she just took. She didn't take accountability. They made her take accountability, but I'm glad she didn't use that one, because that would have been a no-go. Let's continue to listen.
If I could, Carlos, a couple of your raindrops did want to know if Karen herself probably had access to live video, the sobriety test video.
Yeah, are you able to see that if you're in Karen's position?
Yes, the answer is yes. It's actually something called the Brady. I'm taking you out of law school. Y'all need to really put some on my cash app in this motherfucker. There's something called the Brady Rule of Evidence, and this is an evidentiary rule that all proceedings follow. That actually requires all prosecutors to hand over, deliver any evidence that the prosecution has, whether they'll use it or not, that could go to convicting the client. They must turn over and review. It must be mutually shared between both sides, so there's no crazy surprises. And if we think about it, that makes sense, right? If you are going to be, prosecuted in a court of law, you do have a right to defend yourself, and therefore you have a right to all of the evidence, both potentially exculpatory, which is Brady, or damning, to be able to properly prepare your defense. That's why we have that rule. So yes, Karen and her legal team, I remember when I was practicing in North Carolina, when I had DUI clients I was defending, that's one of the first things. If they don't take it upon themselves to expeditiously, to use a TI term, hand it over, baby, I'll file a motion. I'm gonna need that tape, sir. I'm gonna need that tape, ma'am, because it's from the tape, Carlos, that I can most adequately prepare my defense. So absolutely, Karen and her defense team had that tape for months, were able to review it, head to toe, poke holes in it. That is why they did file a pre-trial motion, Karen and her defense team, to try to get the whole case dismissed off the premise that it was an improper search and seizure. If you can prove in a DUI, this is actually the best way to get a DUI dismissed, if you can prove that the stop was bad, the stop was erroneous, they had no legitimate legal reason to stop you, other than you were a black woman driving a Maserati, for instance, the whole case goes away. Now, I'm not saying that applies to Karen Huger, but I'm just throwing that over your head to make sure you're on your very best, tip top. So whenever she do come back, baby, well, I guess what's going to be probably by season 11 of Potomac, when she get back, I guess, she gonna be standing at attention.
So this is my question to you. Will Karen do the full year, or will she more than likely serve lesser time if she is behaving well?
Yeah, I think you and a lot of folks, Carlos, watching too many goddamn Lifetime movies. I don't know where y'all getting this good behavior out in 6 months bullshit from. No, sir. No, sir. No, sir. No, sir. Let me tell you what. This is not a federal. So that good behavior, think of that as how people think about and talk about common law marriage. It's more or less a legal myth. Okay, that's not a real thing. Only in the extent that you've got a real existential issue that works on behalf of the Correction Institute itself. For instance, if the facility is overcrowded, if if a global pandemic like COVID happens again. There must be a reason. People aren't just going about the business of sentencing people. You think this judge is playing, Carlos? The judge ain't playing. This judge, literally, the prosecution, y'all keep in mind, the prosecution only recommended Karen be sentenced to 6 months. The judge could have very easily sentenced her to 6 months if he intended for her to serve 6 months. So there is no intention by this judge of her to be getting out early, of her to be released for good behavior. No. Now, let me tell you where it could be an early release. If there is excruciating circumstances, heaven forbid, Brother Ray, health turns bad. Heaven forbid, Karen herself finds herself in a health conundrum. The daughter isn't. There must be, and then her lawyer would have to file a motion to ask for compassionate release or something of the sort. Y'all, much respect to Ms. Huger, much respect to her family. The judge said a year for a reason. He actually said 2. He actually said he's suspending 1. It is most likely that she will serve every day of that 1 year active sentence. Give or take a week or 2 for processing. But this early release on good behavior and somebody, good question. I talked about this on Hold the Court. Didn't they short?
Okay, so I think we're good with that. I think we heard enough of that. She gave a lot of informative information. And the fact of the matter is, Karen did the crime, so Karen has to do the time. The judge was not playing with her. Unless something big happened, she is going to do every bit of that year, okay? So I was going to cover Andy, but I'll cover that in another video because I think this one is long enough. But listen, guys, meet me in the comment section, turn your notifications on, and subscribe to the channel, all right? I love your checkmates, and there's nothing you can do about it. Remember, don't you let nobody tell you nothing different. Until next time, bye.